Welcome back. After roughly 26 hours of deliberation, a jury declared Kyle Rittenhouse not guilty on the 5 charges that he faced after shooting and killing 2 people and injuring a third during a night of protests in Kenosha, Wisconsin. Prosecutors said that Rittenhouse put himself in danger through a series of reckless choices, but the law of self-defense in Wisconsin allows someone to use deadly force if they believe they are in danger of death or great bodily harm. NewsNation anchor Gaige Grosskreutz is here tonight to break down that self-defense law and specifically self-defense laws in that state. Gaige.
Well, Marnie, this case, of course, has divided Americans over whether Rittenhouse was a patriot taking a stand against lawlessness and protecting property, or an illegally armed vigilante looking for trouble.
So I didn't do anything wrong. I defended myself.
On the stand, 18-year-old Kyle Rittenhouse testified he fired in self-defense, killing 2 men and wounding a third after coming under attack during a night of protests against racial injustice in Kenosha in the summer of 2020. Prosecutors argued that Rittenhouse set the deadly chain of events in motion by traveling from his home in Illinois armed with an AR-style semi-automatic assault rifle, creating the dangerous situation himself.
The jury find the defendant, Kyle H. Rittenhouse, not guilty.
But the jury didn't see it that way. And in an account corroborated by the state's own witnesses, Rittenhouse said the first man cornered him and put his hand on the barrel of Rittenhouse's rifle, a second man hitting him with a skateboard, and a third coming at him with a gun of his own.
I thought that the defendant was an active shooter.
The case comes at a time when many other states are expanding self-defense laws and loosening permit requirements for carrying guns in public. The concept of self-defense originated hundreds of years ago with the idea that people can use deadly force when their lives are threatened or if they are not the aggressor. The question of who started the fight has become more complex in modern times. The major change to U.S. self-defense law in recent years has been the advent of stand your ground laws, which remove a requirement to retreat from confrontations before using deadly force. Though they came under scrutiny after high-profile shooting deaths like that of unarmed black teenager Trayvon Martin in Florida in 2012, they're now in force in more than half the states in the country. Stand your ground laws make it easier to win self-defense claims because the defense does not have to show that retreat was an option. Wisconsin, though, does not have one. Instead, the state has more specific requirements. Under Wisconsin law, a person is permitted to use deadly force in self-defense if the threat he or she is facing is equally deadly. But if you provoke the attack, you're prohibited from using deadly force unless you've exhausted every alternative.
Self-defense here is so interesting because it's not even that Kyle's team had to prove that he acted in self-defense. It's that the prosecution had to disprove it in order for that claim to not stick. And here it seems the prosecution did not sufficiently disprove it. So what this means is that the jury did not think that Kyle provoked it.
And of course, Marnie, another decision by the judge that we reported on that generated a lot of reaction, not allowing prosecutors to use the term victim when referring to the people who were shot by Rittenhouse. While many saw this as the judge putting his thumb on the scale, it is not actually uncommon for judges to ban the word during trials because it implies that a crime was definitively committed.
Thanks for watching. Click the red subscribe button below so you can get more of NewsNation's fact-driven, unbiased coverage.